today. I'm Dr. Brad Goodman, your host today. With me is my good friend, Bernard Nomberg. Bernard is an attorney here in Birmingham. Welcome, Bernard.
Thank you, Brad. I appreciate you inviting me to spend a little bit of time with you and your audience this morning.
Yeah, I appreciate you. And I want to let people know on the front end that you do the same thing I do on Facebook. You have a Facebook live show, really about law, or it's really about anything, frankly. In fact, if you don't mind, I know we were going to talk about law, but just tell our audience a little bit about your show first.
Thank you. I appreciate you asking. It's called Nomberg Law Live, and it started out being a weekly discussion with me and some of my colleagues about different areas of the law. Well, we quickly found out that becomes a snooze fest when you have two lawyers talking about a mundane area of the law, and after 5 minutes, nobody wants to listen anyway, unless you have that particular type of case. So we expanded it. We've done this for about 3 years. We do it every week. We've done about 170 odd shows now, and it ranges from, I could have the general manager of a baseball team, or a yoga instructor, or a local police officer, or you name it, all areas of society. And my tagline is interesting conversations with people in their areas of expertise. And we don't focus on me or our law firm. We focus on the guests, and it's the guest way of educating the public about what they do, and maybe being able to be accessible to people maybe otherwise they aren't. So that's where it's come from.
So I'm gonna plug Doc Talk Live for a minute, and say that Doc Talk Live is not about Brad Goodman at all. In fact, I feel like there could be guest hosts, but really what I want to do is I want to bring health, medicine, wellness, health-related topics. I want to bring it to the public in ways that they can get involved and interact with our guests. And so I'm still struggling with that. I think Facebook is going to allow people that are watching the show to start coming in live. Tomorrow I'm supposed to do a live event in the operating room, so we'll see how that goes. But if I can bring health and medicine to people's phones in a live and interactive and entertaining format, then I've accomplished what I'm trying to accomplish. So I do appreciate your show, because certainly I feel like I can relate to what you're doing, and you can relate to what I'm doing.
And particularly now during the pandemic, when people are really trying to do the right thing and stay home, at least they should be. It shows like yours, it shows like mine, that hopefully brings into to people at their homes new information that they may be looking for.
Sure. So today I wanted to talk to you about law and medicine, and we oh, by the way, so Sherry asked, what time is tomorrow's event? So it's supposed to be at 7:30 in the morning. I am with Dr. Sultan, who is a surgeon. It's going to be a live thoracic robotic surgery, Sherry. So be sure to tune in and hope that I pull it off, okay? Because it's I don't know. I'm a little nervous about it, frankly. Sorry, getting back to you, Bernard, I want to talk to you about the law and medicine. So in this time of COVID, I imagine that patients dealing with issues such as an illness that sort of prohibits them from going to work, even if they're asymptomatic. You could be COVID positive, asymptomatic, but you can't go to work, and you need to work. And so, and you need the money. And when do you get a lawyer for that? And what does the lawyer do? How does all that work?
How much time do we have today, Brad? No, no, I'm kidding. But this is an issue we've been dealing with every single day for almost 10 weeks. Current clients, potential clients, they all want to know, what are my rights and responsibilities about working in Alabama for the companies that I work with? And it is, oh, I'm getting some feedback. Is that on my end?
Yes.
About that. Let me see if I can handle that. Anyway, what the most pressing thing is what I don't want to expose myself in the workplace. I don't want to harm others. I don't want to be harmed because we don't know what the employer is doing with this. So frankly, you need to start with a frank discussion with management, with ownership, with your supervisor. And they're going to hopefully by now, because the dust is settling a little bit, so to speak, about how employers are dealing with this. The more the medical world is learning and teaching the rest of us about the condition and how to deal with it properly from a safety standpoint. Hopefully that's trickling into all of the employers, whether they're big employers or the mom and pop small companies. They all need to take precautions. So what we have in Alabama is an employee at will state, employment at will, which basically means you can be hired or fired at the will of the company for no reason or any reason, so long as it doesn't violate known federal or other types of laws. And as silly as this sounds, if today is green striped shirt day and I'm wearing a solid blue shirt, they can terminate you. I know that sounds ridiculous, but they don't even have to have a reason. So let's look at a real example. Let's say that someone in your house, someone in your house has been quarantined because they do have the COVID-19. They have the condition where they need to be separated from everyone else. But you, the worker, you still have to go to work every day, but you haven't been tested positive. Let's say you've tested negative for this, but you're still quarantined away from the other family member. They're living in the basement. You're living with the rest of the family upstairs. Well, you notify your employer, or they ask you, is anyone in your family symptomatic? Are you symptomatic? They take your temperature, whatever. And you have to tell them affirmatively, yes, someone in my house has the condition and they're living downstairs, but we're quarantined away from them. And your question may be, well, I don't know if I'm symptomatic or not, or have the condition. Do I have to go to work? Should I stay home? Well, your employer is going to expect you at work if you're not symptomatic. If you do not test positive, if you're not a threat to anyone else, they're going to expect you at work. Now, let's change the scenario.
Well, let's stay on that for a second. Let's stay on that. It's going to take 3 or 4 days to get the test results back.
Well, that's where I was going to go with a little bit of this. There's new federal laws that came out in, I think, late March, early April, the Family First Act. There are 2 different segments of that, and I'm not going to get too deep into the woods, and I can share with your audience some links where they can really learn all of the details of it. But let's say that you, under the Family Medical Leave Act, and they've expanded it to allow you, if your company is applicable to the Family Medical Leave Act and you meet those criteria, and they've relaxed most of the criteria, that you can request to be off. Let's say that you're actually caring for someone who has COVID-19, or you have a minor child whose daycare is closed. There's all kind of new provisions that allow you to be off of work, assuming your company falls under the parameters of that. But Brad, where you really hit the nail on the head for the elephant in the corner. What if you don't know if you're symptomatic or have the condition, but you're going to work? Well, then that's on the employer to have open lines of communication with the employee about their expectations, their policies and procedures, which are going to change now because we've never been in this position before. The company still has the right to do its business, to run its business the best they can. And so they have to make a decision about your employment. So maybe the Family First Cares, this CARES Act that has come out, maybe that applies and covers you and allows you to stay home. And there are certain scenarios where you can be paid. But what if it's a small company and you are, I hate to use this term, you're an essential worker to that company. Let's say it's a small car parts company and they're still selling the parts, but you're the accountant for the practice. And without you there, you can't advise the company. Well, maybe you can work out a situation where you work from home. Why do you have to go physically into the the plant, so to
Do
speak.
you mainly represent the employees that have issues, or the employers that have issues, or is it both sides?
Until the pandemic, we've exclusively represented almost 99.9% of my practice has always been representing employees who've been affected by something at work, injuries, discrimination, whatever. But because there's so many questions by so many business owners, we've been fielding those questions as well. And we try to provide both sides of the equation so that the decisions can be made having as much information as you can.
Let's start with the employees.
Okay.
When does an employee need you?
Mm-hmm.
And I'm curious, how do you get paid?
Well, most of these situations in the history of our practice, Brad, because we do Social Security, disability, and workers' compensation, and a little bit of personal injury like car accidents, we sign what are called contingency fee contracts, meaning we're not paid by the hour in those types of cases. Typically, when there's a resolution to one of those types of cases, a certain percentage is paid to us out of the total proceeds. In the last 10 weeks or so, most of our questions and most of what we do by providing answers have been free of charge. We have a very active YouTube channel, and I'm constantly putting videos up there almost every day. We have almost 50 videos just dealing with the pandemic alone that hopefully people find that, and that helps to answer a lot of the questions that most people have. I'm always available to answer the phone, but I can only talk to one person at the time,
Right.
to be effective. But we typically have not been charging just to answer these types of questions.
Take me through some scenario where you're helping an employee, where you're actually getting paid, and how that whole thing works.
All right, let's take a scenario where somebody's been hurt on the job, and now the doctors have said you can return to work in X capacity. It's not full capacity because you're still healing. Maybe in the upcoming months, we'll release you to full capacity again, but your back injury hasn't fully healed. So the employer has to make a decision. Can I accommodate the new restrictions and workplace scenario that the doctors have said, all right, James, your back injury is almost completely healed, but you right now cannot go back into the warehouse. You can only lift 30 pounds occasionally. You can't stoop. You can't climb steps, whatever it is.
So they've been put at light duty.
Look, we'll put them at light duty for this factor. The employer has to make a business decision. I either can accommodate this because I need James in this position, whatever it may be, in a light duty, or I can't. Now, if I can't accommodate, and I don't have to create a job, I just have to accommodate if I can. If they can, then hopefully James comes back into the workplace, pandemic issues aside for now.
Right.
They come back and they do this lighter job for the next 6 weeks until the doctor says, James, your back injury is stable enough to now you can go back doing your warehouse job. And hopefully that's what happens. Or how
do you get paid in that scenario?
Well, that's at the end of the resolution of the work comp case. That's if we settle it through a mediation, or we try the case in court because we still have issues between the parties, and the court awards an order, and from that X dollars we get paid.
How though? I don't. Where is the money? I don't get it.
Let's say that in James's case, we've settled the case for $25,000. We mediated the case voluntarily between the parties. The insurance.
Does that mean there was some sort of negligence because the guy got hurt? Why is there money here?
In work comp, it's a no-fault statute in Alabama. The negligence is not part of this equation. Let's say that James overexerted lifting a 150-pound item that he didn't realize was as heavy as it was, and he slipped a couple of discs in his back that led to a discectomy. He gets a permanent impairment of 5%. He gets limitations after he's gone through his functional capacities evaluation. And from those permanent limitations, the company says, James, I cannot use you in your old job anymore because you can no longer lift 50 or more pounds, which the job requires. We have to let you go. And lawfully, the company can do that because he's an at-will employee. The company has the right to run its business as it deems fit for the business purposes, but they don't have to create a permanent job. Now, that 5% impairment to James's back, plus he now potentially has a vocational disability. And here's where we kind of get deep in the woods. If James can't find a job making $19 an hour like he was doing for the warehouse, if his job is now $13 an hour because he can't do that same kind of work, so for his education and his experience, he's only making $13 an hour as a stock clerk for another company. There's a difference there. There's a vocational loss. So let's say taking that and we kind of, it's like making sausage, Brad. Nobody really knows how to make it, but there's formulas that allow through the Work Comp Act to come up with the values of the case. So before we try the case in court and we say, Judge, this case is worth more than 5% impairment to his back, and here's why, we mediate it with the state ombudsman program. And that's a state Department of Labor ombudsman, a mediator, who brings us all together for an afternoon and we work out our settlement. We demand X dollars, they offer, you work out a mediation. So let's say we've settled at 25 grand. So what does that mean? Well, it means James is no longer employed with the company. He's working somewhere else, hopefully. He has a $25,000 settlement, but out of that, the state law allows us to have a 15% attorney's fee plus reimbursement of our case expenses. So we get paid out of that 25. So doing the quick math, let's say that 21 of that is the net proceeds out of, after you take the fee and the expenses, the rest goes to the client.
So if I hear you right, the injured worker really needs to get an attorney when they're having issues really in going back to full duty or even limited duty, or the employer can't accommodate them because now they've got to find another job.
Most likely that is going to be the scenario. We like it for you to contact us as soon as possible because there's so many pitfalls that they need to be educated. And that's why we have this YouTube channel with literally hundreds of videos of all aspects of employment law, workers' comp from Alabama standpoint, Social Security disability, that these videos are not long. They're 1 to 3 to 5 minutes explaining nuances like how you should be prepared for your doctor's visit, what to say, what to tell the doctor, what notes you should take. Because when you're in there with the doctor, it's like 5 to 7 minutes. You're nervous. You're not going to get all your questions out because you're going to forget because the doctor's going to tell you things that you're not used to hearing. So that's why we have this YouTube channel to help educate the public a little bit.
The scenario I see sometimes is the injured worker has had what you called an FCE, where it's a functional capacity exam or evaluation.
Mm-hmm.
It says, hey, they can do light duty. I see them and I look at their scans and everything, and things are what you use the word healed. In other words, they're not going to harm themselves doing that level of work, and but they may hurt.
Mm-hmm.
And they say, hey, doc, I can't do this because it hurts too bad.
Mm-hmm.
And as a doctor, I can't tell them they can't do it because it hurts. All I can address is harm.
Mm-hmm.
I can say, hey, if you play football for Alabama, you're more likely than not going to harm yourself. You follow me?
Mm-hmm.
So what do you do in that scenario when the patient has been released to some sort of capacity, whether it's regular duty, light duty, full duty, whatever it is, but the patient says they can't do it and the doctor has released them to do it and the employer is accommodating them?
Mm-hmm. You just hit the biggest issue of returning to work arguments that we deal with.
Good.
If it's, I'm going to just a back injury, or neck, a cervical issue, and let's say it's a blue collar type work. We'll put them in the warehouse driving a forklift. And they, in addition to driving the forklift, they're manually moving product and inventory in a warehouse. And let's say that they did go through that FCE, which is not a perfect test for my purposes or for your purposes, because those tests, and I know you know this, but the audience may not know, a functional capacities evaluation is meant to figure out over the course of 2 to 4 hours with a physical therapist who's trained to do this. It's a physical set of tests to see what the limitations are, to see what the abilities are. But the reality is, most of the time, the injured worker who comes to that test is very nervous. They get all jacked up emotionally. They're stressed, and they want to do their best. No one wants to mess around and not do their best. But most are going to give their best exertion doing these tests. But do you really give 100% exertion over a 40-hour work week like you do in that 2 to 4 hour test? Well, there's no test that takes you over the 40 hours. You have to look at that 2 to 3 to 4 hours test when they're getting tested. So from that, the treating physician sees the results and hopefully talks with the injured worker, knowing what they do for a living physically, whatever it's demanding, and they come up with a set of criteria of limitations going back into the workplace from a physical standpoint. It's the best test. It's the only one we have right now. There's lots of holes in it, lots of debate, but that's the only paperwork that the employer cares about, that the doctor has signed off on. The FCE and the return to work paperwork is given to the employer. And let's say in our scenario, it says permanently, James, you cannot lift more than 50 pounds ever again in the workplace. Your surgical site in your neck has a plate and screws. And if you try to lift more than 50 pounds, you're going to risk potential injury either at the site or above or below the site. So the employer says, James, I don't have a job for you. Effectively,
that wasn't my question. My question was, the employer says, I do have a job for you.
Okay.
And James says, I can't do your job. I don't care what the FCE shows.
Okay. James goes back into the workplace, works a couple of days, and is very sore and hurting. James doesn't know if it's from the surgical site or above or below. James just knows in that area of his neck, it hurts. Well, James has the right to go back to the doctor, the work comp doctor, to have it addressed. And the doctor will say, well, it's only been 5 weeks since surgery. It's probably just some residual surgical pain. Or the doctor says, let's do a diagnostic test. Let's do an MRI. Let's see what's going on. Maybe
MRI's unchanged.
Okay.
Everything looks good.
Okay. James has to make a decision for himself, for his body, for his health, for his family. Tough it out or go find another job.
Okay, so that's really what it boils down to.
Absolutely.
So, and what can the attorney do for him in this scenario?
Well, if there's a percentage of impairment, like that 5% we mentioned, let's say, and you don't have to file a lawsuit to resolve workers' compensation cases. We only file them, at least our firm's philosophy, if there is a true issue where my client's rights are not being protected. So let's say that the insurance company about this time makes what we consider to be a lowball offer. We just want to get you off our books and get you out of here. We're going to offer you $4,000 because Alabama is such a low-paying state, actually the lowest in the country, by the way, that you're based on what you make per hour, James, and your age and some other criteria, your 5% is only worth $4,000. So we're going to lowball you, and that's all we're going to offer you. What James doesn't know is there's value to the vocational aspect of his case. The permanent physical injury percentage has a value, and the right to future medical care. Those are the three big aspects to a work comp case. James doesn't know these things, but that's where an attorney who does this comes in. James may have a very good vocational disability case, so we may send him or her to a vocational expert and have an evaluation done, and it's not a physical set of tests. It's just an interview, so the VE, the vocational expert, can determine if there's vocational loss of access to jobs, loss of access to earning. So where we then come in, all right, we've evaluated James's case at 10 times what you're offering. Are we going to mediate, or do we need to file a case and let the judge hear all the evidence to come up with the proper percentage of impairment?
Okay. Let's jump gears and get back to COVID.
Mm-hmm.
Tell us about a scenario with the employee and COVID.
Okay.
Give us a case.
Let's say that in this same warehouse scenario, James is being told by a supervisor, show up for work on Monday or we're cutting you loose. And in this scenario, James doesn't have these restrictions that we just did. James is not injured. James is working in the warehouse. The company is working at almost full. They need James in the warehouse to move product to get it shipped out for the orders. And James says to the supervisor, I know that 2 people in the warehouse who I work near have recently been diagnosed and they're not working right now. That's a concern. It's been a concern for many people. The company says, we're taking all the precautions. There's no COVID in our warehouse, but they don't really know. And James goes to work. And James gets diagnosed after 2 days working there. He takes a test at his one of those walk-in clinics. He gets swabbed, and 2 or 3 days later, by the end of the week, James tests positive and he's starting to feel terrible. James says to the employer, I was diagnosed because of getting exposed in some capacity at the warehouse. These cases are extremely difficult, and that's part of what my part of the bar is discussing right now, is how do you prove that just because James was working in the warehouse where people had been tested positive, that's where he got it, as opposed to going to the gas station or being exposed at home or somewhere in his neighborhood. That's a debate that's going to continue to go on for a long time. Now, in comparison, Brad, and there's not the presumption approved yet in Alabama, but other states are starting to get that way. People on the front line, healthcare workers who are diagnosed, hopefully there's going to be a presumption that if you're diagnosed, if you're a healthcare worker and working and have such exposure, that you might be covered under the work comp laws of whatever particular state that you're in. Not in Alabama, not yet, but maybe other states are further along that way.
So the patient, the workplace wants him back at work.
Mm-hmm.
He has now tested positive, so he can't go to work, right?
Correct.
So now what happens from your perspective? How are you helping this patient? What are you doing to help him?
If the company is subject to those new federal laws that I referred to, he might go out on family medical leave. He might get asked to be terminated, believe it or not, so he could draw unemployment. Depending on what state he's in, he might actually draw more unemployment benefits per week than he would working in the warehouse.
So if you go on family medical leave, you can't get unemployment?
Not necessarily. It's kind of every scenario is a little bit different, but there is a possibility to do both. But you won't get paid if you're out on family medical leave unless you meet certain criteria.
Paid by whom?
Well, if you could get, there are scenarios where you go out on family medical leave if you have saved up sick and accident and vacation pay, paid time, PTO is what it's called. If you saved all of that up, you could be paid that way first. But there are scenarios under the normal, most of the time under family medical leave, your job is protected, but you're not being paid unless there's other ways to get you paid. That's one. Unemployment under the new criteria is another, because under the current criteria, under the Alabama and many states have changed the requirements for unemployment compensation based on COVID, just based on the pandemic. It's a much easier criteria.
So patients are better off sort of consulting your YouTube videos to figure out what to do, because getting you involved in this scenario, there's really nothing for you in terms of other than providing a free service.
If you can look at it that way, but I'm on the phone 80, 90, if I'm not on Zoom or doing a show, I'm on the phone most of the day answering just this same conversations that you and I are having.
I understand. I'm just pointing out that you're on the phone, you're doing this pretty much gratis, because I don't see how you would get paid in that scenario.
That's true, but what it is we're providing information, hopefully, to let people figure out their own scenarios and where they fit in. That's true. You know, they may call me later on with another issue that they
Sure. I just want to understand how the process would work from your end. So anything else you want to discuss on these topics of law and medicine before we call it a day?
As you guys, if you watch any of the news, you see that the laws are changing, not only in our state, but nationally. And that's probably going to continue a trend as we go forward in the upcoming weeks and months, excuse me, until there's a vaccination or some type of medicine that helps, until there's prevention, until things change in our world and all of society gets to open back up, whenever that is. The laws are going to change. They're going to evolve. So what I would suggest that people do is keep themselves as informed as you can, not just about the medicine part, of course, and your health, but how the laws are changing. And that's what our firm is trying to do on the YouTube channel. We could have this same conversation this time next month, and some of my responses today are going to be invalid or changed because if the law changes.
So when we hang up and Christy, posts the show for us, will you make sure you get with Christy so people can see the links to your YouTube videos and your Facebook Live and your law firm? Absolutely.
I can put it in the comments section or give it to her.
Perfect. Bernard, I'm inside. I don't know. Is it a nice day? Are you going to get out today?
And today is not a hike day. I hiked yesterday in the mud. Today is hopefully yoga, stretching, and a little bit of weights day, but it'll be on my front porch, which we've turned into on the side note, we have a big old house and an awesome big front porch with windows, but it's now where we eat all our meals. It's where we do all of our exercising and hanging out. I don't even stay inside unless I'm asleep. But I love that front porch, but that's where I'm going to be this afternoon.
And how are your kids? How are they? Where are they?
Well, at 21 and almost 24, they're going stir crazy like all kids that age. My Emily, who's a junior, well, now a senior at Georgia undergrad, she's been at the house for 10 weeks and she's so itching to get on with life, as they all are. Sydney, my older child, is happily employed in the wedding and party planning industry, which is very, very busy right now, thankfully. They're pushing things back into the fall and next winter, but she lives right around the corner, so we get to see her quite a bit as well. So thank you for asking.
Great. It's great to hear from you, Bernard. Thank you for doing this. And as topics may come up, please contact me and say, hey, Brad, I'd really like to do a Doc Talk Live. This is a subject that really needs to be covered if those things come up. So
be glad to anytime, Brad. Thank you.
Appreciate it, Bernard. Take care.
Take care.